We will now turn from talking about records of a public office to meetings of public bodies, which is governed by Ohio's Open Meetings Act. During this segment, we will review important definitions, obligations imposed on public bodies, executive session, and liabilities that can result from violating the OMA. The Open Meetings Act applies to all decision-making bodies of the state, its political subdivisions, and school districts that are created by law, including any committees and subcommittees. The OMA imposes certain requirements on public bodies when they conduct meetings, a term that has a very specific definition under the law. A meeting occurs when there is a prearranged gathering of a majority of the members of a public body for the purpose of conducting or discussing public business. A frequently overlooked part of the definition of a public body is that the Open Meetings Act expressly applies to all committees and subcommittees of a public body, even though these committees do not make the final decisions of the main public body. This means that committees and subcommittees of a public body must comply with the same obligations. The next important definition is for the term meeting. The three elements of a meeting are: 1, it must be prearranged; 2, there must be discussion of the public business of the public body; and finally, there must be a majority of its members physically present. When all three of these elements exist, the obligations of the Open Meetings Act must be complied with. Public bodies must conduct their public function in meetings in order to comply with the openness requirement of the OMA. Prearranged work sessions or retreats, for example, where public business is discussed among a majority of the members of a public body, are meetings and must be noticed and open as any other meeting would be. What is important is whether all three parts of the definition are present, not what the actual gathering is called. Meetings only exist when there is deliberation or discussion of public business. Discussion is an exchange of words, comments, or ideas. Deliberation involves the weighing and examination of reasons for and against a course of action. Some courts have found that certain types of activities do not constitute discussion or deliberation. A gathering of the members of a public body is not a meeting where they only are gathering information or attending presentations, or when employees are having isolated conversations. Public bodies have to comply with three obligations when they conduct meetings. First, they must give appropriate notice of the meetings to the public. Second, they must take action and deliberate on public business in open session. And third, they must take and file meeting minutes. Under the law, public bodies must give notice of their meetings in a way that is consistent and reasonably reaches the public and the population that the public body serves. While some public bodies have laws that specify the method by which a public body provides notice of meetings, most public bodies do not have such laws. Those bodies are required to establish rules, policies, or bylaws for providing notice. The type of notice that a public body must provide corresponds to the type of meeting that it intends to conduct. There are two types of meetings: regular and special. Regular meetings are held at pre-scheduled intervals, for example, the first Thursday of every month. Special meetings include all meetings other than a regularly scheduled meeting and include regular meetings that are rescheduled to a different time or place. If a public body is hosting a regular meeting, the notice the public body gives must include the time and place of the meeting. Notice of a special meeting must include the time, place, and purpose of the special meeting. When a public body notices a special meeting, it must provide at least 24 hours advance notice to persons and the media who have requested it. A type of special meeting is an emergency meeting. These types of meetings are conducted in the event that there is an emergency that requires the public body to take immediate official action. Notice must be sent immediately. As a type of special meeting, a public body must include the time, place, and purpose of the emergency meeting in its notice. The required immediate notice must be sent to any media organization that requested to receive such notice. The Open Meetings Act also requires a public body to establish a method by which a person may sign up to receive notice of meetings when a particular topic or type of public business is going to be discussed. The public body may charge a reasonable fee to send this type of notice. The OMA suggests that one method of arranging for this kind of notice is for the requester to provide a self-addressed stamped envelope. A public body's second obligation is to ensure that meetings are open at all times. This means that public bodies must vote on and take all official action in open session. The purpose of the openness requirement of the Open Meetings Act is to allow the public to observe the workings of a public body. Engaging in secret discussions or round-robin meetings violates this openness requirement. Round-robin meetings are separate meetings that are each attended by less than a majority of the body's members, but when taken together, a majority of the members have discussed and deliberated on the same topic. Also prohibited is voting by secret ballot or whispering discussions of a public business rather than talking so that the public can hear. Finally, the Ohio Supreme Court recently held that the OMA prohibits any prearranged private discussion of public business by a majority of the members of a public body by electronic means, such as email, text, or tweeting. The space in which a public body meets must be open to the public. The public body must also have its meetings in the proximity of the area that the public body serves, and the venue must be large enough to fit the anticipated audience. A public body cannot ban the recording of its meetings, but a public body can modify its rules to limit recording if it disrupts the meeting. Finally, the OMA requires that attendees be able to hear meetings but not necessarily participate or offer input. Public bodies may want to establish rules and procedures for when and if they permit members of the public to speak during their meetings. Let's apply what we've gone over. So, what if a township trustee holds a regular meeting where all the members attend and provide the proper notice to the public, but the doors to the meeting are accidentally locked while the meeting is ongoing? Is this meeting open or not open? Here, proper notice was given, minutes were taken, but because the door was locked, the meeting was not open to latecomers and the OMA was violated. A public body's final obligation under the Open Meetings Act is to take and keep full and accurate meeting minutes. Minutes must be prepared promptly, filed, and maintained by the public body. They also should be made available to members of the public in response to public records requests. Minutes do not need to be a verbatim transcript of exactly what was said and what happened during each meeting. However, minutes must contain enough detail to allow the public to understand and appreciate the rationale behind the public body's decisions. The only time that members of a public body can meet privately behind closed doors and not in open session is when they are holding an executive session. A public body can meet in an executive session to discuss very specific topics. Discussions in executive session should be limited only to those specific topics. A public body must follow proper procedure to recess into executive session. First, there must be a motion that states the purpose for the executive session, and the motion must be specific as to the matters to be discussed. The reason for the executive session must be exclusively for the purpose of considering one of the statutorily approved topics. Any discussion on that topic in executive session must be limited to the specific topic identified in the original motion. The motion must be followed by a second, and then a roll call vote by a majority of the quorum to adjourn into executive session must be made. This roll call vote must be recorded in the minutes. A meeting must always begin and end in open session to allow the public to understand when the meeting and executive session began, the purpose of the executive session, and when the executive session concluded. There are 9 acceptable executive session topics that are all identified by statute. I won't go through all of these in detail, but you can see them on the slide before you. It is important to identify which executive session topics pertain to your public body and make sure that the motion sufficiently identifies the topic to be discussed in executive session. For example, a motion to go into executive session for just personnel matters is not enough. However, a motion for executive session to discuss the hiring of a new executive director would be sufficient. Whenever a public body is going into executive session, it should ensure that it satisfies the requirements of the statute for going into executive session to discuss a particular topic. Let's take another opportunity to apply what we have discussed. Here, township trustees want to go into executive session to discuss a general OMA issue. The chair moves to adjourn with the board's attorney to discuss some legal matters with the attorney for the trustees, and then there is a roll call vote. Was this an appropriate or inappropriate motion? Here, the meeting started in open session, so that requirement was satisfied. There was a roll call vote, which is required to go into executive session. But the motion was to discuss some legal matters, which is not one of the pre-approved topics for an executive session. so this motion was not proper. It is possible that the legal matters the chair wanted to discuss were pending or imminent legal action that could be discussed in executive session, but the motion was not properly specific. So who can be present in executive session? Board members can be present. The majority of the board, however, going into executive session cannot exclude the minority of the board that voted to not go into executive session. In addition, anyone else that the members of the public body wish to invite may be present. Nothing in the OMA provides for confidentiality of discussions or documents discussed in executive sessions. However, other laws, like ethics laws, for example, may require confidentiality, but only for the board members. Even when a public body has properly gone into executive session, there still can be limits on what it can do. A public body may not vote or make any decisions in executive session. That includes things like straw polls. And a public body may not discuss other matters not included in the motion for executive session, even if they are related. The Open Meetings Act does not contemplate that members of a public body can participate in meetings virtually through methods like Skype or teleconference. In order to be considered present for purposes of establishing a quorum and for voting, a board member must be physically present, unless specifically authorized by law. Currently, only the Ohio Board of Regents and one county organization are allowed to have virtual member participation. If any person believes that the Open Meetings Act has been violated, that person may file an injunction action, which, if granted, will compel the members of the public body to comply with the law. The action must be filed in the Court of Common Pleas where the meeting at issue took place, within 2 years of the alleged violation. This action cannot be brought in the Ohio Court of Claims like the Public Records Act. There is no public entity, not the Attorney General's office or a county prosecutor's office, that has the authority to enforce the OMA. If an injunction is issued, the court shall order the public body to pay a fine of $500 for each violation found to the party that filed the action. In addition, the court must award all court costs and reasonable attorney's fees. However, the attorney's fees award may be reduced or not awarded at all if the court finds that 1. A well-informed public body reasonably would believe that the body was not violating the Open Meetings Act, and 2. A well-informed public body reasonably would believe that the conduct that was enjoined served the public policy underlying the authority asserted for the conduct. Any decision made or adopted outside of an open meeting is invalid, even if the formal action is adopted in an open meeting. If the deliberations were improperly made in a meeting not open to the public, the decision can be invalid. In addition, if proper notice of a meeting is not given, any action taken during that meeting could be invalid. Deficient minutes, however, do not invalidate the actions recorded in those minutes. A member of a public body that continues to violate an injunction against them for past violations of the law may be removed from office by the prosecuting attorney or the Attorney General. If you have any questions about either the Public Records Act or the Open Meetings Act, the Ohio Attorney General's office has resources available to help answer them. The Attorney General's website has a dedicated Sunshine Laws page, and you can also access the Ohio Attorney General's Sunshine Laws Manual, which is the most comprehensive guide to the Public Records Act and the Open Meetings Act in the state online. Also, feel free to give the Public Records Unit a call anytime you might have a question about Ohio's Sunshine Laws.